Probably the most enduring argument, and one that was made back in the Nixon administration with Senator Saxby's nomination to be Attorney General, is, look, don't worry about what the words say. The purpose of the clause is to prevent corruption, to make sure that a senator or congressman doesn't get to reap the benefit of a salary increase that happened on their watch. And the argument is, well, geez, Senator Clinton, even if the salary of Secretary of State went up while she was in office, it's gone back down, or it's going to go back down, presumably, when the president signs the bill. She won't get the benefit of that salary increase, so no harm, no foul. The purpose of preventing this sort of self-dealing is preserved. But the problem with that argument is, if you actually go back and look at what the framers said back in 1787 when they were putting the Constitution together, that wasn't their purpose behind the Emoluments Clause. There would be some discussion about the self-dealing elements of the clause, but that was by far a subservient purpose to what were larger purposes dealing with the proponents of the clause's concerns about the size of government. What we had, if you actually go through and you look at what was said in the debates, virtually every framer who was supporting an Emoluments Clause, or what became the Emoluments Clause, was concerned not with self-dealing, but with the likelihood that the federal government was going to expand. And they saw the Emoluments Clause as a way to stop, or at least discourage, what they viewed would be a natural expansion of the federal government, by discouraging members of Congress from being involved in creating new offices that weren't needed, or raising salaries of current offices beyond the levels that were really necessary. I mean, you had George Mason, who was one of the biggest proponents of an Emoluments Clause. He complained that the British Crown had increased its power by creating executive offices, and said the Emoluments Clause would be the cornerstone on which our liberties depend by, quote, removing the temptation to create new offices. Colonel Mason later said that the clause would help avoid the creation of a federal aristocracy where members of Congress would come to Washington, and then when their terms ended or when they wanted to leave Congress, they would just transition into other federal jobs here in Washington, like cabinet positions and the like.
Too late.
Elbridge Gerry, another anti-federalist who was very much behind the Emoluments Clause, said that the clause would reduce Congress's temptation to create new offices and thus limit the power the federal government would wield as compared to the states. Framer James Wilson explained that the clause would discourage the government from, quote, creating unnecessary offices or granting unnecessary salaries. James Madison, who ultimately crafted the compromise into what became the final version of the clause, said that the unnecessary creation of offices and increase of salaries were the evils most experienced. And the thing that's striking about all of these remarks from the debates at the Constitutional Convention is they're all focused on the front end. They're all focused on discouraging the creation of offices and discouraging the increase in salaries. Hardly at all were the framers who spoke on the clause concerned with the fact that at the back end, a member of Congress might get a salary increase that they had some role in causing, or get appointed to an office that they helped create. Now, I will grant that these views about the growth of the federal government and concerns about federal oppression might seem very outdated today, given the size of the federal government that we have today and the way that the United States government has changed. But what I would say about all that is the people who argue for looking at the purpose of the Emoluments Clause are ones who want to avoid what it says. Well, what it says is that someone in Senator Clinton's situation is ineligible. And so if the argument is, let's ignore what it says because we can meet the purpose, then you got to deal with the purpose that actually existed. And what you can't do is say, ignore the plain language because we're satisfying the purpose, and then just create a purpose that was more convenient than the one that actually existed. In some ways, I think the best argument for enforcing the Emoluments Clause is that it's just silly. Senator Clinton's, the Secretary of State's salaries increased $5,000 in Senator Clinton's current term. I will completely grant that that has little bearing on Senator Clinton's aspiration to be Secretary of State. But it seems to me that there are a lot of silly provisions, or arguably silly provisions in the Constitution that we adhere to because they state a rule and you have to follow the rule. A particularly mature 33-year-old can't run for president because you got to be 35. Arnold Schwarzenegger cannot run for president because he was a naturalized citizen. And those are just ironclad rules that you have to follow. The Emoluments Clause is not stated as in vague terms or in aspirational terms. It's very concrete in what it allows and what it doesn't. And it seems to me that what it doesn't allow is Senator Clinton to be appointed as Secretary of State during, at least until 2013, or Senator Salazar to be appointed to Secretary of Interior until his current term ends. Now, the history of the Emoluments Clause is that members tend to raise it as a bar to appointment only when they've got some other axe to grind against either the nominee or the president. It came up as a big issue when Senator Hugo Black, was going to be appointed to the Supreme Court. And the backstory there was that it had come out that he may have been a member of the Ku Klux Klan. And so the Emoluments Clause was likely a convenient excuse for opposing his appointment. Same thing with Senator Saxby. His appointment as Attorney General occurred right after the Saturday Night Massacre at the height of the Watergate scandal, where President Nixon's Attorney General and Deputy Attorney General resigned because they didn't want to fire the special prosecutor. So at that point, you had a number of senators who said Saxby fix doesn't work. It's unconstitutional. You had Justice Breyer, who at the time was a Harvard law professor, saying that's right, that the Saxby fix cannot remove an increase in emoluments that occurred. And you had other law professors saying the same thing. So I would expect that President Bush is going to sign the bill that will reduce the Secretary of State's salary, and likely the President and Congress, likely the Congress would confirm Senator Clinton as Secretary of State, because I don't see that there's a political axe to grind in Congress that's going to cause something else to happen. I want to close by saying that I do not purport in any way to be an expert on foreign affairs. I have no view on Senator Clinton's fitness to be Secretary of State on the merits. My view is solely on the constitutional issue, which I staked out 13 years ago. I think it's unconstitutional, and I don't think reducing the salary restores her eligibility to office. Thanks.
Thank you, John. Very elucidating. Ilya, as I said, you and the other blogs were the first to kind of bring it up in to the attention of the media, and you posted an interesting blog yesterday talking about how you kind of helped get it going. I thought if your remarks could cover that as well, I'd appreciate it.
Sure. It just goes to show that I have even less of an interest in grinding axes or whatnot. I haven't written a law review article on it. I have read both of the law review articles that cover this subject. It's a rich literature. John's, of course, is the seminal one, and then Michael Paulson wrote one called "Is Lloyd Benson Unconstitutional?" And I think Professor Paulson, who's a law professor at St. Thomas University in Minnesota, couldn't be here, so I'll sort of step in his shoes a little bit with the analysis that he's brought to bear.